Hello and good afternoon to everyone. My name is Philip Hoddell and I'm the new chairman at Burkitt Long. I'm delighted to welcome you to this Wednesday webinar. Burkitt Long are offering fortnightly webinars on a range of different subjects. In the coming weeks, we'll be providing updates on construction law, employment law, and rent arrears in the commercial property sector. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. That's www.burkittlong.co.uk/events. Today's webinar is being presented by Thomas Emmett, Head of Education Law at Burkitt Long. Thomas is an expert on all matters to do with schools, colleges, and the education sector. I will now hand over to him without further ado.
Thank you very much, Philip, for the introduction, and good afternoon, everyone. As Philip just said, my name is Thomas Emmett and I am the Head of Education at Burkitt Long. The education team here advises educational institutions as well as parents, carers and young people on education law, including admissions appeals, exclusions and SEN law. But in respect of educational institutions, it also advises on property law, commercial law, data protection law, health and safety and more. Today, I'm going to be providing what can only be described as a brief introduction to SEN law for SENCos. I say brief because 1 hour is not enough time to cover the entirety of SEN law and the complexities of it. However, I hope today provides an insight into a number of different things relating to SEN law, including the sources of it and some of the key areas. Next slide, please. Before I go into the substantive part of the webinar, just some housekeeping. Firstly, the presentation is just for general purposes only and does not constitute legal advice. The information is correct as at today's date. In terms of questions, we will take questions at the end, so I'd ask you to use the Q&A facility as we go along if you have any questions that you would like me to answer. Next slide, please. So, as I said at the outset, I'm going to cover the sources of SEN law, and that is my first topic for today. I'll then move on to consider some of the key definitions in SEN law, which are important to understand for the purposes of comprehending and applying SEN law generally. I will then discuss some of the key areas of SEN law. That includes the duties the law places on educational institutions relating to SEN, needs assessments, EHCPs, and the changing or amending of them. We will then move on to questions. Next slide, please. So before discussing SEN law itself, I think it's useful in the first instance to go into what makes up SEN law and where it can be found. The place to start, I would say, is always the Children and Families Act 2014. From the 1st of September 2014, a new legal framework for SEN law was introduced with the implementation of that act. The legal framework relates only to the law as it applies in England and contains the legal rights to ensure children and young people with SEN or a disability receive the educational provision required as a result of their needs. Having regard to the need to help those children and young people achieve, using the words contained in section 19 of the Children and Families Act, the best possible educational and other outcomes. But other than the Children and Families Act, which we'll be hearing about a lot more during this presentation, what else makes up SEN law? Well, firstly, there is the foundation of it, which is founded on what we call Acts of Parliament or statutes, and I will talk about some of the key Acts of Parliament in a moment. Secondly, there are regulations. They contain detail which flesh out the Acts of Parliament. You'll often find things such as time limits, which by law must be adhered to in such regulations. An example of a regulation is the Special Educational Needs and Disability Regulations 2014. Thirdly, there is statutory guidance. Arguably, the most important example of statutory guidance in this context is the SEN Code of Practice. Statutory guidance does not have the status of statute or regulation, but local authorities and various other bodies must have regard to it, which means they must comply with it unless there is an exceptional reason not to. Fourthly, there is case law, and SEN law is continuously developed by the bringing of cases to challenge uncertainties in the law. A judge's interpretation of the law becomes much as part of the law and SEN law as acts of parliament, and as I said before, this is known as case law. Turning back to acts of parliament or statute, in addition to the Children and Families Act, there are some other important acts which you need to be aware of, including, but certainly not limited to, firstly, the Education Act of 1996, which was the key act in relation to SEN law before the introduction of the Children and Families Act. Parts of the Education Act 1996 do remain in force, and that includes the sections dealing with entitlements to free home to school transport, some basic definitions used in the law, such as the definition of child and compulsory school age, which we'll come to later on, and section 9 of that act, which is an important section in the context of a parent's choice of school or other institution named in an EHCP. In addition, there is the Children Act of 1989 and the Chronically Sick and Disabled Persons Act of 1970, and these are relevant statutes in relation to social care needs of children with disabilities. There is the Equality Act 2010, which I'm sure most of you have heard of, which is a key piece of legislation in relation to children and young people with disabilities. And then finally, in respect of other statutes which I think are of particular note, is the Mental Capacity Act 2005. And I would also pay or point to in particular that sits alongside this act, the Mental Capacity Act Code of Practice, and this becomes relevant in the context of whether a young person has the mental capacity to make particular decisions. Next slide, please. So when you know what SEN law is made up of and where it can be found, the next question is, who does the law apply to, or what is the scope of SEN law? And as a starting point, and as you can tell from the slide, it applies to children and young people. Each of child and young person has a definition in law, which is contained in Acts of Parliament or statutes. Next slide, please. And it is important to go into the definitions contained in these Acts of Parliament. So the word child is actually defined in section 579 of the Education Act 1996 as a person who is not over a compulsory school age. Broadly, this means up to the age of 16, because section 8 of the same act states that compulsory school age starts at 5 and ends at the school leaving date, which is currently defined as the last Friday in June, which falls in the academic year in which the child turns 16. The definition of child also covers those below compulsory school age, so there is no need for a child to be at school to benefit from the protection of the Children and Families Act. A young person is defined in section 83(2) of the Children and Families Act, and it means a person over compulsory school age but under 25. Broadly, therefore, the definition of young person means from 16 and up to 25 years old, and a child becomes a young person for the purposes of the law when they reach the age of 16. Next slide, please. So we know from what I've just said that SEN law applies to children and young people from the age of 0 to 25, but it does not apply to all children and young people between those ages. To determine which children and young people in particular it applies to, you need to look at the Children and Families Act. In that act, there are references to children and young people having either a disability or a learning difficulty. You would also see references to special educational needs, as you might expect. It is important to understand what disability, learning difficulty and special educational needs are from a legal standpoint to be able to determine if the Children and Families Act and the rights deriving from it apply to a child or a young person between the age of 0 and 25. Starting with special educational needs, Section 20 of the Children and Families Act states that a child or young person has special educational needs if he or she has a learning difficulty or disability which calls for special educational provision to be made for him or her. This definition has two elements. The first is the child or young person must have either a learning difficulty even, or a disability, and the key word there is and, that the learning difficulty or disability must require special educational provision to be made for him or her. To determine if a child or young person has special educational needs as defined by Section 20, you need to break the two elements down and consider what the law determines to be a learning difficulty or a disability and what it considers to be special educational provision. In terms of learning difficulty or a disability, Section 22 of the Children and Families Act also states a child of compulsory school age or a young person has a learning difficulty or disability if he or she has a significantly greater difficulty in learning than the majority of others of the same age, and that's Section 22A of that Act, or has a disability which has a disability which prevents or hinders him or her from making use of facilities of a kind generally provided for others of the same age in mainstream schools or mainstream post-16 institutions, and that's Section 22B of that Act. Section 22A is what many people think of when they consider what is meant by the term learning difficulty. So that's a significantly greater difficulty in learning than their peers. Section 22B deals with a different situation where the child or young person in question may not have a learning difficulty directly as a result of any learning disability. They may, for example, be intellectually bright, but because of their disability, as defined in the Equality Act, which I'll go into later on, he or she is unable to access mainstream education or training without some steps needing to be taken to enable that to happen. In other words, they are prevented or hindered from being able to access education in the same way as their typically developing peers. Section 23 of the Children and Families Act is about children under the compulsory school age, and it states a child under compulsory school age has a learning difficulty or disability if he or she is likely to have anything or likely to be within even what I've just described in respect of those of compulsory school age. So it's future looking in terms of will that child, when they come to the age of compulsory school age, will they have, or will they likely to have a learning difficulty or a disability which affects their ability to access some of the facilities in mainstream education. It's important to recognise as well Section 20, subsection 4 of that Act, which contains a negative. It sets out specifically a situation which does not constitute a learning difficulty, and this is important. It states a child or young person does not have a learning difficulty or disability solely because the language or form of language in which he or she is or will be taught is different from a language or form of language which is or has been spoken at home. And this means that children who have a greater difficulty in learning than their peers, which arises because their home language or dialect is different to the language in which they are taught, does not constitute a learning difficulty as defined by the law. Those particular individuals fall at the first hurdle in the question of whether or not they have special educational needs in the legal sense. Now we've considered the first element being learning difficulty and disability, we now have to consider what is meant by in law by special educational provision. Remember, in order for a child or young person to have special educational needs in law, both elements must be satisfied. They must have a learning difficulty or disability, and this must call for special educational provision to be made. Therefore, it is important to understand the term special educational provision, and this is defined in section 21(1) of the Children and Families Act, which states that special educational provision for a child aged 2 or greater or a young person meets educational or training provision that is additional to or different from that made generally for others of the same age in mainstream schools, maintained nursery schools, mainstream post-16 institutions, places in England which are relevant early years education and where that's provided, and special educational provision for a child aged under 2 means educational provision of any kind. The key words to notice are that special educational provision needs to be additional to or different from the educational provision made generally for others of the same age in mainstream maintained environments across the whole of England. Next slide, please. In terms of disability, which is obviously a key definition in SEN law, this can actually be found, the definition can be found in the Equality Act 2010, and the Equality Act states a person is disabled if the person has a physical or mental impairment, and that impairment or mental impairment and that impairment has a substantial and long-term adverse effect on the person's ability to carry out normal day-to-day activities. It's important to note this test is different. It's about the ability to carry out normal day-to-day activities. But unless that child or young person also has a need for special educational provision, the parts of SEN law which confer entitlement on children and young people with special educational needs, such as the entitlement to an EHCP, will not apply to them. A child or young person might have special educational needs and a disability, or only one. For example, a child or young person with dyslexia or on the autistic spectrum may have SEN but not be disabled, although of course they may be. It depends on the impact of the condition on their ability to carry out day-to-day activities. A child or young person with complex medical needs may be disabled but not have SEN. A person with cancer, for example, is deemed to be disabled under the Equality Act. Again, there is a possibility of overlap, but don't make the mistake of thinking that all children and young people with SEN are disabled or vice versa. In each case, the different legal tests have to be considered and applied. Next slide, please. So we go back to the original question, and that's what children and young people have entitlements under the law. Well, using the law and the legal definitions we have gone through, and there's some general statements that can be made. So children and young people who do not have either a learning difficulty or a disability as defined by the law will not be covered by SEN law generally at all, because they do not have a learning difficulty or disability. Children and young people who have a learning difficulty but who are not disabled and do not have special educational needs as defined by law, perhaps because the learning difficulty they have does not require special educational provision, is not considered in law as having special educational needs, because adaptations can be made by their class teachers without any special help, and therefore they would not be eligible for something like an EHCP. Children and young people who have a disability but do not have special educational needs, because the disability they have does not require special educational provision, have some elements of SEN law that applies to them, but they will not be eligible for an EHCP because the gateway to the plan is having special educational needs. And then, of course, there's children and young people who have a learning difficulty or a disability and that do have special educational needs, because the learning difficulty or disability they have requires special educational provision, and the school or post-16 institution they're attending are not able to arrange the special educational provision, and therefore they would be entitled to an EHCP. Of course, there are those with learning difficulties as well, or a disability, that do have special educational needs, and it does require provision, but a school or a post-16 institution is able to arrange the provision they need. And therefore it is questionable in such circumstances whether an EHCP would actually be needed for that child or young person. Next slide, please. I want to, and to a certain extent quickly, just because these are duties on schools. Whilst I think are useful, there are some more engaging topics later in the presentation. I think it's important to set out what duties actually apply under the Children and Families Act and related legislation, regulation and guidance to schools, nurseries and post-16 institutions as well. If I was first to turn to section 34 and section 35 of the Children and Families Act, it's what I describe as the inclusion sections, and I'll explain why in a minute. But before I do so, it's just quickly worth pointing out that not all the sections that I refer to here, the law in those sections doesn't necessarily apply to all schools or institutions. It depends on the type of school or institution. So you just need to be aware of that as I go through this section of the presentation. So turning back to the inclusion sections, section 34 of the Act applies to children and young people who have SEN without an EHCP. The law says such children must be educated in mainstream settings, and therefore mainstream educational institutions must educate such children and young person, subject to some rare exceptions. Section 34 states a child or young person in England who has special educational needs, but for whom no EHC plan is maintained, if he or she is to be educated in a school or post-16 institution, then there are a number of exceptions that apply, as I previously mentioned, and these include obviously where the cost is not met by the local authority or the Secretary of State. So that's things like private schools and private education, specialist settings that are being paid for by the parent. Other exceptions are where the local authority, the head teacher or principal and the parent or young person are in an agreement, and a child or young person could be admitted to a specialist provision for the purposes of an EHC needs assessment. And in this case, the child or young person may remain admitted to the specialist setting until an EHC plan is made, unless the LA decides not to issue a plan, in which event the child or young person may only stay for a period of 10 school or institution days after serving notice of the LA's decision. A child can be, or a young person could be admitted to a special school which is established in a hospital, and this is another exception. A child or young person could be admitted to a specialist setting without an EHCP where there has been a change in his or her circumstances. The SEN code refers to this as an emergency placement and says that local authorities should immediately initiate a needs assessment or reassessment. And for more information on that, you should see paragraph 1.29 of the SEN code. For this exception to apply, there will need to be an agreement between the local authority, the head teacher or principal, and the child's parent or the young person. And there are a few other exceptions which I think is beyond the scope of this presentation to go into. The last provision, which was actually a cause of much concern in 2014 when the Children and Families Act was going through Parliament and the years before, particularly taken together with the fact that the provisions of the SEN code dealing with SEN support and the section 66 best endeavours duty do not apply to special schools. The SEN code says that that academies need to make clear through their funding agreement that a child or person with SEN but with no plan should only be placed there at the request of their parents or at their own request and with the support of professional advice, such as a report from an educational psychologist. Quickly to mention section 35, which contains an important duty which applies to maintain nurseries and maintain schools, where such settings are concerned with the making of special educational provisions for a child. This applies only to children, so up to the end of the compulsory school age, and that's 16. The duty is to ensure that the child engages in the activities of the school together with children who do not have SEN, subject to certain exceptions, which again are outside the scope of this presentation, but to briefly mention them. The children receiving special education, it's outside the provision of efficient education for children with whom he or she should be educated, or outside the efficient use of resources. Next slide, please. So section 68 contains a duty on schools, nurseries, or certain schools and nurseries to inform parents and young people if special educational provision is being made for a child or a young person. And this section applies to maintain schools, maintain nursery schools, academy schools, alternative provision academies and PRUs. This only applies when no EHCP is maintained for the child or young person. So this provision specifically relates to children and young people without EHCPs. The law requires an LA to inform a parent or young person if they are considering making a needs assessment of a child or young person's need. There should therefore never be an instance where a pupil is receiving special educational provision and the parent or the young person does not know about it. This applies to all maintained schools and academies, and so does apply to maintained or academy special schools. All children in special schools will have an EHCP, and so this is less likely to be relevant, but it would apply for those children without EHCPs who are admitted to a special academy by way of one of the rare exceptions in section 34 of the Children and Families Act. Section 69 of the Act contains the information duties upon the governing bodies of maintained schools and maintained nurseries and what are described as the proprietors of academy schools. Again, because this presentation is aimed at SENCos, I will not go into any detail or specifically go through those. Next slide, please. In your role as SENCos, I'm sure you're very aware of EHC needs assessments and making applications for such assessments. An EHC needs assessment is defined in section 36 of the Children and Families Act as an assessment of the educational, healthcare and social care needs of a child or young person. The first step towards a needs assessment is to trigger the requirement for a local authority to make a decision about whether or not to carry out an EHC needs assessment for a child or young person. And this can happen through two different legal routes. That's either a request is made of the local authority to carry out an assessment under section 36 of the Children and Families Act for a child or young person, or the LA, that's the local authority, becomes responsible for a child or young person under section 24 of the Act. For the purposes of today's webinar, we'll focus on the first one, that is the making of a request. A specific request for an EHC needs assessment to be carried out by a local authority may only be made by the following people. That's a child's parent, a young person, which, if the young person lacks mental capacity, will be the parent or other representative of the young person, or a person acting on behalf of a school or post-16 institution. When a request is made under section 36, the authority must then determine whether it may be necessary, keywords being may be necessary, for special educational provision to be made for the child or young person in accordance with an EHCP. In other words, the local authority has to make a decision as to whether or not special educational provision may be necessary to be made in an EHCP. This is a low bar to meet because the obligation is to consider whether it may be necessary. The local authority has a duty to consult the child's parent or the young person before making its decision, which gives the parent an opportunity, if they have not done so already, to explain why they believe that the child has or may have special educational needs and why provision is or may be required to be made in accordance with a plan. From the date of receiving a request from a parent, a young person, or otherwise, the LA must, within a maximum of 6 weeks, notify the child's parent or the young person of its decision as to whether or not it is necessary to secure an assessment for the child or young person. Within the 6 weeks, if the local authority is considering securing a needs assessment, the local authority must notify the child's parent or the young person. The SEN regulations state this must be done as soon as is practicable after the LA receives the request. It must also notify various other persons, including any responsible commissioning body, the social services part of the local authority, in relation to a child in early years education, the person responsible for SEN in relation to the provider, in relation to a child or young person at school, the head teacher of the school, and in relation to a young person at a post-16 institution, the principal of that institution. There are limited exceptions to that duty. Having made its notifications and carried out the required consultations, the LA must then make its determination, and there are only two possible answers, yes or no. Often there is an issue of whether or not the local authority applies the right legal test, but for the avoidance of doubt, the legal test is as follows. The local authority must secure an EHC needs assessment for a child or young person if, after having regard to the views expressed and evidence submitted by the persons that I've just referred to, the authority is of the opinion that the child or young person has or may have special educational needs, and it may be necessary for special educational provision to be made for the child or young person in accordance with an EHCP. It is likely that the LA will have its own policies as to whether or not to secure a needs assessment, but to the extent that they are stricter and or impose other additional requirements to what is contained in the law, they are unlawful. Just for your own information and something you can go away and look at yourself if you so wish, paragraph 9.14 of the SENCos sets out some guidance as to what is deemed necessary. So it says it may be necessary special education provision to be made, and that sets some examples where it's likely to be necessary for provision to be provided to a child. Next slide, please. If the local authority does decide that it's going to secure an assessment, the Special Educational Needs and Disability Regulations 2014 at Regulation 6 state the authority must seek the following advice and information. That's the needs of the child or young person, what provision may be required to meet such needs, and the outcomes that are intended to be achieved by the child or young person receiving that provision. The reference in that regulation is simply to needs. However, bear in mind that a needs assessment is specifically defined as an assessment of a child's education, healthcare and social care needs. These, therefore, are the needs about which advice and information must be sought, and this is reflected in the SEN code. The list of persons for whom the advice and information should be sought is also included in the regulations. It's regulation 6 for anybody who's interested. And that is the advice and information from the child's parent or the young person, educational advice and information from the head teacher or principal of a school or post-16 or other institution that the child or young person is attending. Where this is not available, from a person who the local authority is satisfied has experience of teaching children or young people with special educational needs, or knowledge of the differing provision which may be called for in different cases to meet those needs. Or if the child or young person is not currently attending a school or post-16 institution or other institution, and advice cannot be obtained from a person responsible for educational provision for that child. If any parent or young person is serving member of Her Majesty's Armed Forces, then it's from the Secretary of State from Defence. They need to receive medical advice and information from a healthcare professional from an identified responsible commissioning body. Psychological advice and information from an educational psychologist, advice and information in relation to social care, and advice and information from any other person the local authority thinks is appropriate, and some others that are contained in Regulation 6. There are some exceptions to this, but again, for the purposes of this presentation, it's outside of the scope. Next slide, please. As I said previously, there's two possible outcomes from, or should I say, Like previously, there are two possible outcomes after a needs assessment, and that is the local authority will decide that an EHCP will be issued and they will issue a draft plan, or the local authority will notify a parent or young person they've decided not to issue an EHCP. The local authority must give reasons if they are notifying the parent or young person that they are not going to notify, they're not going to issue an EHCP, or if they are going to issue an EHCP, there should be reasons as well. The legal test, and this is important, the legal test which the local authority must apply in coming to the decision about an EHCP is set out in section 37(1) of the Children and Families Act, and it states as follows: where in light of an EHC needs assessment, it is necessary for special educational provision to be made for a child or young person in accordance with an EHCP, the local authority must secure that a plan is prepared for the child or young person, and once prepared, it must maintain that plan. Local authorities may have their own policies, but if they are stricter than the legal test I have just described, they are not lawful. The legal test is whether it is necessary for special educational provision to be made for a child or young person in accordance with an EHC plan. Next slide, please. So we've been talking about a lot about EHCPs, and now I think it's important just to touch on what the law says EHCPs are. I'm sure you're aware in your own mind what they are, but I think it's important to state what the law describes them as. And under section 37 of the Children and Families Act, it states that an EHC plan is a plan specifying a child or young person's special educational needs, the outcome sought for him or her, the special educational provision required by him or her, any healthcare provision reasonably required by the learning difficulties and disabilities which result in him or her having special educational needs. In the case of a child or a young person aged under 18, any social care provision which must be made by him or her by the local authority as a result of Section 2 of the Chronically Sick and Disabled Persons Act 1970, and any social care provision reasonably required by the learning difficulties and disabilities which result in a child or young person having special educational needs, to the extent that the provision is not really already provided elsewhere in the plan. I think it's important to have a look at the various sections of an EHCP, which I'm sure many of you are aware of, but I will go into each of them because around some of them, certainly section F, there is a lot of law, and I think it's important we go into that in some degree in this presentation. So let's start with section A, and as most people know, it's a section where the views, interests and aspirations of the child or the young person or the parents of a child are set out. Some local authorities do write the section in the first person, and if they do, it has to be clear whether they are the words of the child or the young person being quoted, or that of a parent or a professional interpreting their views. Section A will be the place to include any relevant history of the child or young person. This section should also include a summary of how to communicate with the child or young person and engage them in decision making. However, it will be important when reading the plan to ensure that wording which constitutes the child's special educational needs or provision is not included in section A, as it is essentially an introduction with no legal effect. Section B, this is the section where the child's special educational needs should be listed and is a key section of the EHCP. This section should reflect all the educational difficulties identified in the parents and professionals reports obtained during the assessment process. Each report gathered through the statutory assessment process should be analysed. It will be necessary to go through all the advice and reports, highlighting each difficulty and checking whether section B has included them. Section C, the EHC plan must set out the healthcare needs which relate to a child or young person's special educational needs. The SENCo gives routine dental health as an example of routine healthcare needs which would not relate to special educational needs. The SENCo also says that the clinical commissioning group, which is responsible for healthcare provision, may choose to specify other health needs which are not related to a child or young person's SEN. Section D, this is where the social care needs of a child or young person which relate to their special educational needs or disability are set out. If the information provided to the social care team as part of the needs assessment indicates that a child appeared to have social care needs, this should have been a trigger for a social care assessment under the Children Act of 1989, which would have identified social care needs. Section E, this is where the outcomes for a child or young person are included. The SENCo explains that there should be a clear distinction between outcomes and provision, and defines an outcome as the benefit or difference made to an individual as a result of any intervention. I would point you in particular to paragraph 9.66 of the SENCo, which is particularly helpful in respect of outcomes. In my view, it's necessary for parents and young people to pay particular attention to this section, and there should be an outcome relating to each of the identified needs, as well as provision designed to work towards that outcome. This will be important as children get older, in particular in the context of when an EHCP could be ceased and in relation to reviews and reassessments. Section F, and this is where the special educational provision must be set out. The definition of special educational provision in section 21 states that this should be anything that's additional to or different from that made for others of the same age. So this could cover anything from the provision of worksheets in larger font through to one-to-one adult support. And paragraph 9.69 of the SENCo gives some examples of provision or what provision should look like in section F, including that it should be detailed and specific. And the idea of detailed and specific provision in section F is subject to various case law, and I mentioned case law previously at the start of the presentation. I would point you to a recent article I did on specificity and the level of detail you need in section F, because the position is changing somewhat, or is becoming more flexible, or the judges seem to be opening the door to more flexibility. But I wouldn't move away from the idea that the provision contained in section F needs to be detailed, quantifiable and specific as a starting point. Important to note when it comes to section F, section 21(5) of the Children and Families Act, it states that healthcare provision or social care provision which educates or trains a child or young person is to be treated as special educational provision, and that's instead of healthcare provision or social care provision. And that means such provision should be put in section F. Section G is about health provision reasonably required by the learning difficulties or disabilities which result in the child or young person having special educational needs. That this must be set out in this section, and that is subject to the agreement of the responsible commissioning body. Section H is split into two parts. H1 is the social care provision that must be made under section 2 of the 1970 Act, and H2 is any other social care provision reasonably required by the learning difficulties or disabilities which result in a child or young person having special educational needs. And then there's of course section I, which is often subject of a number of SEN tribunal claims each year, and that is the name of the school or post-16 institution in which a child or young person is to be placed, or alternatively the type of school or institution. Section I of the final EHCP must set out the type of school which is considered appropriate if it's not going to name the particular school, and it doesn't always necessarily need to name a particular school. Section J relates to direct payments, which I won't go into here. And section K lists the advice and information that's obtained during the needs assessment. I think it's important just to go back to section F for a minute. It's arguably the most important section in an EHCP, and it's subject to a lot of case law around things like, as I mentioned before, how detailed, specific and quantifiable provision needs to be. I would highlight that whilst there is a lot of individuals, groups, etc., that have very good intentions in respect of actually looking at EHCPs for parents and have to a certain degree expertise, I would recommend considering the cost effectiveness of a lot of EHCP check services that solicitors provide, actually asking a solicitor to look at it for the purposes of enforceability. Because the worst thing that can happen is that an EHCP is finalised, the time period for bringing an appeal is passed, and then the provision is not provided, and you're then trying to rely on a plan that is not specific enough to be enforceable, meaning that you might have to, for example, look for an annual review or an emergency annual review and then start going through those sort of processes again, which isn't ideal. So if you get a draft EHCP, my suggestion would be that you seek legal advice from someone that is legally qualified to do so. And talking about enforceability, it's important to highlight section 42 of the 2014 Act, and that relates to section F and also section G in relation to the enforceability of healthcare provision. Next slide, please. Just quickly, in terms of changing the EHCPs, I've mentioned that in terms of annual reviews, from the point in which the first EHCP is finalised within the period of 12 months, starting with that date, there must be an annual review. The local authority must organise that, and in each subsequent period of 12 months after that, there must be a review as well. An annual review is not simply a meeting, as I'm sure you're aware, which takes place to discuss the child or young person. It should be a meeting that is essentially an information gathering exercise, looking at the plan in light of the information that's been gathered, and then deciding whether to amend or cease the plan or to leave it alone. All of these elements have to be in place, and the last element in the process is the notification of the decision to the LA as to what's going to happen with the EHCP. In terms of amending an EHCP following the review, obviously adjustments will be made to the EHCP. Again, you're looking for the things such as specificity and the detail to make sure that any changes, certainly to section F, are enforceable, but in other sections that it's clear as to what's being said, and that needs and provision are clearly set out, and that includes everything. And if you're not happy, you need to make that known. And then if you're not happy and they finalise the HCP, which can often happen, you need to exercise your right of appeal in those circumstances, or a parent needs to exercise, or the young person needs to exercise their right of appeal. And our experience at the moment is that local authorities will take it right down to the wire just before the tribunal hearing and then concede. It's not ideal that it goes to that point. However, at least if there's any silver lining, the adjustments that are looked for by the parent is in the end implemented. The question is whether the way in which the parent has included what they're looking for in the HCP is again clear enough to be enforceable in a legally binding contract, which a plan is. And again, I think that's where solicitors and other legally qualified individuals who specialise in this type of work can be extremely valuable. Just a point to note in terms of reviewing draft EHCPs, I've heard a lot of clients talk about the idea that that it's 15 days, and it's no more or no less. It'd be 15 days to look at the draft EHCP. That's not what the law says. The law says at least 15 days for parents and others to make representations and to request a particular score of institutions. So that's worth bearing in mind. And I think from my point of view, that's the end of that slide. Moving on to the survey. Thank you very much for listening. Before we take questions, we'll be, just so you know, we'll be sending recording around to everyone that signed up for today's webinar tomorrow morning. Apologies, I can't go into as much detail as like, but we have a limited amount of time and the law in this area is vast. But I hope as SENCos and other interested parties, you have benefited from the insight into the law in this area. And hopefully, if you have any questions, happy to answer those. The survey that was just previously put up just then, we'd appreciate any feedback that you've got. And upcoming events in terms of the education side of things. We're happy for SENCos to join us on this Q&A that's on the screen, but it's also relevant for parents, carers, guardians and young people. We have a Q&A that is run by myself and a colleague in the education team, Kimberly Hercog, and it is very much an open forum whereby you can ask us absolutely anything relating to SEN law, EHCPs. We're happy to provide feedback through the Q&A. So that's the details are on the screen there. I'd also like to point you to our Facebook group, and you can see details there. Our solicitors in the team are providing input on that Facebook group after questions are raised by not only parents, guardians, young people, but we've had lots of SENCos join the group. We're happy to answer any questions on there. Sort of a word of pre-warning, if you like, there are certain occasions where we do have to refer you to sending us an email, essentially, because we can't address the question in the forum of a Facebook group. But we're finding that it's very useful for people to be able to get in contact solicitors in a rather informal setting. And there have been a number of occasions where individuals have emailed us directly and we're happy to get back to them. So again, thank you for listening. This is the question part of the webinar. Do we have any questions? I've got a couple of people that you can't see that are sitting in the background ready to share the questions. So any questions at all?
Hi Tom, yes we do. I'll kick off with a question from Kerry. My local authority have said that for an application of assessment of needs for an EHCP, they require professional agency involvement, which will include an educational psychologist. When I've questioned it, they have quoted the Code of Practice. My reading of the Code of Practice that actually it says that the assessment of needs is a bit that requires the local authority approved EP. Is there law that I can quote to challenge this, as they cannot provide EP sessions as they are overstretched?
Okay, Kerry, thanks very much for your question. If I'm understanding your question right, and if you don't get the answer you're looking for from my answer, please do send me an email, and I'm happy to go into this in a little bit more detail. But for the purposes of a needs assessment, you don't need any sort of report. You need to make, in fact, it can be as simple as a letter. You simply need to make an application to them. They will sometimes have their own forms, but again, this isn't necessary. And ask for an assessment, and with that request, you need to put in as much information as you can and that you have, and of course any professional reports would be useful, stating why you think a needs assessment is required. And I would point you back to the test that I went through during the presentation about needs assessments. And during the presentation, I went through what they need to consider when you have the needs assessment, or when they first receive your request, and then what they should be doing to then finally make a call based on that legal test, that statutory test, as to whether a needs assessment should take place. So I don't agree with the idea that the law requires you have any sort of psychologist reports or anything like that comes with an application for an assessment. Thank you.
Thank you. The next question is from Kate. Is part-time attendance at school sufficient reason to apply for an EHCP? The child has ASD, high anxiety, has been on a part-time timetable attending 40 to 60% for 3 years, but has no support, so we haven't been able to progress any further.
Yeah. Okay. That's not uncommon. My advice to you would be to make the application. I don't know all the details. Obviously, you've given me some information in relation to, I presume, your child. I don't want to say specifically as to whether an assessment will be made based on the information you're providing me on a webinar, but in terms of I suppose the part-time attendance at the school, I suppose if the reasoning relates to the fact that provision isn't working in terms of meeting the child's special educational needs, and I think that's certainly helpful in respect of a needs assessment application. I hope that helps.
Thanks, Tom. Next question is from Liz. Should a child with CF be able to get a needs assessment?
So that's an interesting question. I suppose you have to go back to the legal tests that I referred to during the presentation. I don't think you can point to a particular learning difficulty or disability and say, OK, that in abstract means that there should be an assessment and there should be an EHCP. You need to look at the legal tests, taking into account everything you know about a child or young person, or the child or the young person, and see how that applies to the particular circumstances. And if in the circumstances the tests are met, then yes, you should have a needs assessment, and then you should be, and if the test for the granting of an EHCP is met, then an EHCP should be issued. But in abstract, it's difficult to say for sure. But if you would like to send me an email providing me more details about the child or young person, happy to provide some more input as and when.
Thanks, Tom. An anonymous question. When does anxiety become a SEND disability, such as EBSA?
Again, I think you need to, and I'm just going to unfortunately keep referring you back to legal tests, unfortunately, because I can't specifically say, OK, there is a particular point with a particular disability or learning difficulty where, it's likely in the circumstances there'll be a needs assessment and an EHCP will be issued. I think, you need to set out, let's say in your application for a needs assessment to the local authority, what the child or the young person is essentially experiencing. And the extent to the anxiety, and does the effect of that mean that special educational provision is required above and beyond what is provided at school? Now, if you can make a case for that, then there is an opportunity there for an assessment and perhaps an EHCP. But I would need much more information to be able to give a firmer guide as to whether it's likely to bring about a needs assessment and an EHCP thereafter.
Thanks, Tom. The last question, all the other questions that we've had come in, we're collecting email addresses so we can contact them. Again, it's an anonymous question. In regards to the law and definitions of SEND, would that mean pupils who have been permanently excluded and are attending an alternative provision would be considered SEND?
The short answer to your question is no, not necessarily. I must admit, in terms of the question you're asking specifically, I'm not entirely sure I can provide the answer, because in respect of SEN, it's looking at well, what I referred to in the presentation in respect to that definition of special educational needs, and I'm not entirely sure sort of where the provision, if you like, or where education is being provided links to how or whether someone has special educational needs. So if you'd like to clarify the question in an email to me, or provide me a little bit more detail so I can give you the answer that you're looking for, I'm happy to do that, but I'm not sure the idea of what constitutes special educational needs from a legal standpoint is impacted by what institution they attend, or what type of institution they attend.
Thanks, Tom. That's all the questions that we have for today's session.
Thank you very much, and thank you all to those who have attended today's webinar. What I would say to you is watch this space, SENCos, in respect of further input that Burkitt Long will have in terms of training. We are certainly looking at doing more in terms of legal input or legal guidance for SENCos on SEN law and the SEN system, because SENCos aren't trained lawyers, and I appreciate in the current circumstances and the current system, and I'm not entirely sure whether the SEN review is going to make this any better. To a certain degree, it's kind of expected that you are. So we are going to be putting on more events in the near future for the benefit of SENCos. So watch this space is my message. Thank you again for joining me this afternoon, and have a good evening.